So we'll see the remaining questions, okay?
Yes.
There was one question on differentiate between administrative law and constitutional law. Okay, that we will see. Because these two are sort of related, we can say. So this question is there, differentiate between administrative law and constitutional law. Okay. So when we talk about administrative law is subordinate to constitutional law. We know that Constitution of India is like supreme law of land in India, right? All the other laws that we have, it should be in conformity with whatever is mentioned under Constitution of India. So that's the reason why we say that administrative law is subordinate to constitutional law.
Yeah.
Whatever is mentioned in Constitution, it has to be in conformity with that. If Constitution talks about equality, the administrative officers must act in that manner only. They cannot go against the provisions of equality like that. Okay, so administrative law is subordinate, but constitutional law is supreme or highest law of the country. Administrative law is species of constitutional law, and constitutional law is always regarded as the genus. So constitutional law is like a broader concept. Okay, Constitution talks about different public officers, their privileges, immunities, how they will be appointed, their powers, functions are mentioned. Okay, so it is like a broader concept taking everything together, but administrative law mainly deals with administration. How we can make sure that these bodies or these different officers are performing their functions properly without acting in an arbitrary manner, without going against provisions of Constitution. So Constitution is like a broader concept which covers everything: appointment, tenure, privileges, the different bodies also, right? Like Union Public Service Commission, State Public Service Commission. These are also mentioned under Constitution itself, right? But when we talk about administrative law, it's like a species of constitutional law. It's like a part of Constitution, or like a small part of Constitution, or subordinate to Constitution, which ensures proper functioning of these different bodies or these different departments. Okay. Administrative law deals with the organs of state as motion. Constitutional law mainly deals with various organs of the state. When we talk about constitutional law, it talks about 3 different organs of the government, right? So what are the organs?
Legislative, executive, judiciary.
Yes. And these 3 organs exist both at center as well as at state level as well, right? Both central also, state also, it is there. So when we talk about constitutional law, it deals with those various organs of the state, whether we talk about central level or state level, who all will be there, how their appointments would be done, powers, functions, everything. But when we talk about administrative law deals with organs of the state as motion, how these executive bodies are expected to perform their functions, what is expected out of them. If they are going beyond it, what will happen in motion, right? When they are acting, when they are performing their functions, what all things they need to take care of, that mainly we get in administrative law. Okay, is it clear?
Yes.
Administrative law mainly deals with the various functions of the state. Constitutional law mainly deals with structure of the state. So Constitution tells us that India is a democratic country. We have parliamentary form of government and all that, right? India is a republic. India is a secular country. It mainly tells us about structure of the state, what kind of a state India is. It also says that, okay, India is a welfare state. It thinks about welfare of people. Right, so Constitution deals with what kind of a structure we have in India, what is the structure of the state that it talks about. But administrative law mainly deals with various functions of the state. When we say that, okay, India is a welfare state, to be a welfare state, it should perform some welfare functions also. And those welfare functions, who will perform what, how they will be executed, that is mentioned under administrative law. If you have different schemes, which department is going to execute that scheme, how it will happen, what if some corruption is there, all of that is dealt under administrative law. Administrative law does not deal with all branches of law. Rather, it deals with the powers and functions of administrative authorities. Our main focus is administrative authorities or the executive organ of the government. But when we talk about constitutional law, even though not in detail, but roughly, it touches all the branches of law. It gives guidelines with regard to general principle relating to organization and powers of organs of the state and their relations between citizen and towards the state. Constitutional law talks about all the three organs of government, who are all the members of those government. Everything is given under constitutional law. But administrative law is only concerned with executive or administrative organ of the government. Okay. Administrative law does not deal with international law. It deals exclusively with the powers and functions of administrative authorities. Constitutional law gives guidelines regarding international relations also, like directive principles of state policy, right? There it says that, okay, India should try to maintain friendly relations with other foreign countries. If there is any sort of dispute that arises with a foreign country, India should try to settle it amicably rather than fighting. That is nothing but it's giving guidelines on how we can maintain international relations in a better way. But administrative law is not concerned with international relations or anything. It's only about how within India, executive bodies or different administrative organs are expected to perform. Okay. Administrative law deals with the powers and functions of administrative authorities, including services, public departments, local authorities, or other statutory bodies exercising administrative powers or quasi-judicial powers, etc. Constitutional law deals with the general principles of the state pertaining to all branches. All the three different branches, whatever important matters are there, like elections, how they will be elected, what will be their tenure, what will be their salaries and allowances, what oath and affirmation they will take before joining office, everything is given there. But administrative law is only concerned with different administrative bodies or different administrative organs, how they are expected to perform their functions properly. That part is dealt under administrative law.
So administration involved in election commission or election process, those areas does not come under administrative law, madam.
Election commission, when we talk about election commission, the people who are there, like the election commissioners, members, those also we can say they also fall under administrative law. They also should perform their functions properly. Administrative law is concerned with the organization of services or the working of various government departments. Constitutional law demarcates constitutional status of ministers and public servants. So constitutional law says about president, council of ministers, right, governor, council of the chief minister, all those different positions, right, members of parliament, like that it talks about. But when we talk about administrative law, it is concerned with organization of services and working of various departments. There are different departments, what is their hierarchy, how they are expected to perform, what all principles they are expected to follow. That is mainly what we get in administrative law. The administrators have to follow constitutional law first and next administrative law. If constitution is saying that, okay, we need equality before law and equal protection of law, that first that should be ensured, because that is mentioned under constitution, and constitution is supreme law of land in India. Okay, so constitutional law imposes certain negative duties on administrators if they are found violating fundamental rights of citizens and etc. So when you look at Part 3 of Constitution, you will see some negative obligations are imposed. The state shall not discriminate. The state shall treat equally, like that. The state shall not discriminate. The state shall not deprive a person, like that. Some negative duties are imposed under Constitution. And administrative bodies or administrative authorities, they are expected to perform or follow these duties, okay, whatever is imposed under Constitution. It also imposes certain positive duties on administration via implementation of social welfare scheme. If you look at part 3, fundamental duties, fundamental rights, there you will see state is having some negative obligations that you should not discriminate, you should not do this, so that people can enjoy fundamental rights. If you look at part 4 of Constitution, it talks about some positive obligation that the state shall try to provide right to education, right to work, right to health, nutrition, and all of that. As in part 4, directive principles are some positive obligations or positive duties on administration. And when we talk about the part 3, fundamental rights, it is some negative duties. So all of that we get under Constitution, and whatever is there, administrators, they are expected to follow that. So Constitution is also like giving some guidance or giving some principles on how they should perform their duties. Like in broadly, it's telling about the duties and the obligations of even these administrative officers as well. Administrators should perform their functions with utmost obedience to constitutional law. Administrative law is just a subordinate to constitutional law. Constitutional law has complete control on administrative law and administrators of the country. So whatever is mentioned under Constitution, that is supreme. First, that needs to be followed. After that, only all the administrative bodies and everything would come. Because Constitution is like permanent. When we talk about administrative bodies, if tomorrow government feels, they can even say that this certain body will not exist from tomorrow onwards. That is also possible. Okay, certain department, they might say that this certain department will cease to exist from, like tomorrow. That can also happen. So Constitution is like supreme, administrative law is like a subordinate body only. Okay, is it clear?
Yes.